I'm Joel Ngugi. I'm the presiding judge, Nakuru High Court, and also the chair of the Task Force on Alternative Justice Systems. The work of the task force was to do this. First, to determine the prevalence of the use of alternative justice systems in resolving disputes. Two, to map out the kinds of dispute resolution mechanisms that are out there, and then come up with a model for use of alternative justice systems that will either intersect or not intersect with the judiciary, but in a way that's in obedience to the constitutional commandment. So one of the outputs of the task force became a policy, a national judicial policy on alternative justice system. We did organic anthropological studies. We went on the ground, interacted with practitioners of AJS, interacted with policymakers, interacted with different courts and judicial officers who operationalize or not operationalize AJS when they intersect with the courts and so forth. And we did a lot of learning from what was going on in those places. We adopted at least 7 pilot stations of court annex AJS systems, and then just learned, watched, observed, interacted, engaged. The policy comes up with operational doctrines for judicial officers and judges that they will be using when they come across AJS questions in practice. We've laid out those doctrines, and we have suggested which ones are compatible with the Constitution and which ones are not compatible with the Constitution. The last major recommendation that we've made, that the judiciary has the primary duty under the Constitution to promote the use of AJS. That means, among other things, not to regulate AJS mechanisms. That will be a bad idea, but it will mean engaging, providing training, providing technical assistance to these mechanisms, but also to come up with operational doctrines that ensures that the Bill of Rights and other minimum constitutional provisions are adhered to in the operationalization of these AJS mechanisms. Some of the challenges that we will come across is, first of all, there's the age-old challenge of resources. If we are serious about the question of promoting alternative justice systems, it means that we must fund the process. We must fund the engagement that is envisaged in the Constitution. Promoting means enabling, facilitating these AJS mechanisms. That means the practitioners need to understand their place in the Constitution, the limitations that the Constitution places on them, and so forth. That will require strategic engagements with them, which will require resources. We do believe that this policy is a game changer in justice conversations in these countries, especially in terms of ensuring access to justice as guaranteed by Article 48 of the Constitution of Kenya, but also in keeping with Sustainable Development Goals number 16 as well, which talks about the rule of law and the need to ensure access of justice, especially for the poor. The poor largely, disproportionately, access justice through alternative justice systems in Kenya. And so if we start transforming those spaces, then we ensure that there is access to justice by the poor who otherwise are not accessing justice, or are not accessing justice that has been transformed by the ethos of the Constitution.